China is one of the leaders in the production and supply of goods. For many countries, Chinese partners are very important in their economic activities. The legal basis for the supply of goods is an agreement between contractors. It doesn't matter at all where the buy of the goods is located. It doesn't matter where your office is. The delivery point doesn't matter. The jurisdiction doesn't matter. The contract is similar for all countries. They apply universal legal norms. The agreement will work and protect your interests. Let's first talk about the most basic principles of contract terms. The first, the contract must be written and signed by both parties. The second, in international contracts, the parties choose the law, code, and application of Incoterms. The parties can choose the international rules of Incoterms. What does it mean? International rules were created to make it easier for partners to draft an international contract. Incoterms have several versions. Partners can choose any version, but they must specify the year in the contract itself. Let's imagine that India and China decided to enter into international contract for the supply of goods. India will be the seller. The parties decided to use Incoterms and deliver goods by ocean. They can choose the CIP rule. This means that the seller must insure goods, pay customs fees and import duties, load the goods and deliver to the buyer. Responsibility of the partners. The contract should discipline the partners. All obligations must be fulfilled correctly and on time. It could be fine, compensation for expenses, warranty period and force majeure situations. The specificity of international contracts is that the parties choose the law of which country they will apply and in which court the dispute will be resolved. The choice of law means that the dispute will be resolved according to the law of this country. These questions could be: first, transfer of ownership of the goods; second, responsibility of the parties for violation of obligations; the third, condition when a contract is considered concluded, and how the quality of product is assessed. We will briefly describe all the options, advantages and disadvantages of choosing court. First, state court of one of the parties. Second, commercial arbitration in the country of the party to contract. To choose a court, you need to write about this in international supply agreement or draw up an additional arbitration agreement. Freight forwarder. The issue of transporting goods from point A to point B is also very important. The forwarder finds the best way to deliver the goods and is also responsible for the delivery documentation. The forwarder may also, on behalf of the parties to the contract, enter into contract of carriage with a transport organization. In an international contract, the parties can choose a forwarder and can decide how his service and transportation of goods will be paid. Certificate of quality and quantity of goods. For example, the Indian side supplies pens to the Chinese side. There may be 1,000 or 10,000 of them. To avoid a dispute over the return of replacement of goods, the parties find an independent expert, wrote about this in the contract and decided who will pay for it. The expert assesses the quantity and quality of the goods and report this to the parties. Details of the parties, the international contract. At the end of the contract, it's important to mention information about the counterparties. This will be information about the contract number, names of organization, countries, date and place of signing, and terms. In our modern world, trade turnover with China is increasing, and the supply of goods is one of the most popular economic activities. In such situation, the international agreement for the supply of goods will be your reliable protection and will make your work with the counterparty easier.